Who are intermediaries and explain liability of intermediate? June 2018. Intermediaries and their liability under IT Act 2000. Who are intermediaries? Intermediaries are entities that facilitate online communication, data storage, or internet services between users. They do not create or modify the content but act as a conduit for information exchange. Examples of intermediaries include Internet Service Providers, ISPs, example Jio, Airtel, BSNL. Social media platforms, example Facebook, Twitter, Instagram. Search engines, example Google, Bing. Web hosting services, example GoDaddy, AWS. Online marketplaces, example Amazon, Flipkart. Messaging services, example WhatsApp, Telegram. Liability of intermediaries under IT Act 2000. The Information Technology IT Act 2000, particularly Section 79, provides a safe harbor to intermediaries, meaning they are not held liable for user-generated content if they meet certain conditions. This provision ensures that online platforms are not unfairly punished for the actions of their users. However, there are specific responsibilities that intermediaries must follow to remain protected. Key provisions under Section 79. Exemption from liability. Intermediaries are not responsible for third-party content hosted on their platforms unless they have played an active role in its creation or modification. Due diligence obligation. They must follow guidelines issued by the government, such as taking down illegal content upon receiving notice. No direct control over content. If an intermediary acts as a neutral platform without active interference, they are protected. Takedown mechanism. If notified by an affected party or the government about unlawful content, example defamation, copyright violation, hate speech, they must remove it promptly. Exceptions where intermediaries are liable. An intermediary loses protection under Section 79 if it knowingly publishes or promotes illegal content. It fails to act on a lawful takedown request. It is actively involved in the content's creation or modification. It violates government-mandated rules and regulations. Examples of intermediary liability cases. Google India Pvt. Limited v. Vishakh Industries, 2020. The Supreme Court of India held that intermediaries cannot claim blanket immunity and must act responsibly in removing defamatory content. Facebook and WhatsApp encryption debate. The government has asked platforms to trace the origin of fake news and unlawful messages, raising concerns about privacy versus accountability. Bennett Coleman and Co. Limited v. Union of India addressed concerns over copyright violations and whether search engines should be held accountable for displaying pirated content. Recent developments and IT Rules 2021. The Information Technology, Intermediary Guidelines and Digital Media Ethics Code, Rules 2021 strengthened intermediary obligations. Significant social media intermediaries, SSMIs platforms like Facebook, WhatsApp, and Twitter must appoint a grievance officer to handle user complaints. Identification of first originator. Messaging apps like WhatsApp must help law enforcement trace the origin of messages in serious cases like fake news, terrorism, or child exploitation. Faster content removal. Intermediaries must act swiftly in removing unlawful content when notified by authorities. Accountability of social media influencers. Platforms must ensure that misleading or harmful content by influencers is regulated. Punishments for non-compliance. Failure to comply with intermediary guidelines and regulations can result in severe consequences. Loss of safe harbor protection. the intermediary can be held directly liable for any illegal content on its platform. Legal penalties: the IT Act imposes fines, takedown orders, and potential criminal action against responsible executives. Criminal charges: under Section 69 of the IT Act, non-compliant platforms can be blocked in India. Conclusion: intermediaries play a crucial role in digital communication, but they must adhere to legal frameworks to avoid liability. While safe harbor protections exist, non-compliance with IT laws can lead to legal consequences, fines, or platform bans. The IT Rules 2021 have further tightened obligations, especially for major social media platforms, ensuring they actively regulate content and respond to legal notices. As digital platforms evolve, maintaining a balance between free speech, privacy, and legal responsibility remains a challenge for governments, users, and tech companies alike.